Judge, how has your caseload changed since you assumed senior status in 1997?
Well, I have taken, I actually took senior status a couple of years before the age in service would have kicked in, because I'm a senior judge by reason of disability. I had a very bad heart problem, and the doctor thought it'd be better if I taper off. And so Judge Newman was the chief judge at that time, and
it's Judge John Newman.
Yeah, John Newman. I wrote to him, and he certified, my doctor certified, that it'd be better if I took senior status, and so we applied to President Clinton, and a letter behind me thanked me for all the work and hoped I would continue. And luckily, I have been feeling pretty well, and I have continued. I've taken the load of a regular senior judge, which is, well, it's not, in our court, our seniors all take 1/2 of the load of a regular judge, of an active judge. And I've done that as well. My understanding is you keep your active or senior status just by taking 1/4 load, but all our people take about 1/2. And that's what I do. So I sit 1/2 the days of an active judge. And I choose to sit a week at a time. Some of my senior colleagues like to take 2 days here, 3 days there. I think you get the better feel of it when you do a week. It's very wearing. And in recent years, or years ago, when I have to go more frequently, my wife and I would go down and stay there for the week. And now what I generally do is commute from Hudson. It's about a 120-mile drive, but my clerk drives me down. We go right into the courthouse and the parking garage and up to the chambers and out on the bench, and we leave mid-afternoon, so I get back to Hudson, and I feel much better doing it that way. But of course, the cases that I'm taking are the same cases the active judges sitting next to me are hearing. And so I take whatever assignments I'm given to write decisions and participate in the motions, and do a regular weekly stint with the court. And I still enjoy it very much. I still try to do some other things like writing and teaching, and hope to do so as long as my health permits.
You mentioned previously in our conversations that you had sat by designation on the Fourth Circuit. Have you sat on any other circuit?
No, I haven't. I haven't sat on the Fourth Circuit, and I haven't sat on any other court in the Fourth Circuit. I enjoyed it down there very much, especially that week I sat down there. At that time, my son was working next door in the state capitol as press secretary of the governor, and so the Fourth Circuit experience was excellent. I expect that now that my wife and I are kind of relocating for the winter months to Phoenix area, that I'll be sitting with the Ninth Circuit sometime or other. I've already written to the chief judge out there. She's chambered in Phoenix, as a matter of fact, and told her that I'd be available to sit in Pasadena. The court sits there every month, as I understand it, and it's not a bad commute. One day drive maybe to get from Phoenix to Pasadena. I would stay there for a week and look forward to that, as well as the teaching at the Arizona State University Law School.
Judge, before we discuss any specific opinions of yours from the circuit, of course you've led and continue to live a full life, not just on the bench, but off as well. I wonder if you could give us an idea of your family life and other private interests that you've been able to pursue during your busy legal career.
Well, my wife and I, of course, have always been very close, and our sons are now scattered, so it's just us together. And we've gone a couple of years ago, we did a round-the-world trip that we enjoyed very much. We went to places that we wouldn't go this year, but we did get a nice view of the world. We've gone to every state in the Union. As a matter of fact, my wife insisted that the boys visit every state before they went to any trips overseas, and so in their youth we had a van we would rent in the summertime, one of those recreational RVs, same as the one I explained to you that we campaigned in for the Supreme
Right.
Court. As a matter of fact, we came back from a trip with the kids in an RV just when we got that word about the state court. So we would take them and pile them in and drive around the country in the summertime. My wife did most of the driving. She was the better driver, but they were great ways to go, and we did a little camping and a little touring, and we saw the sights. The boys saw all the sights of the country. And so it was an interesting trip. We spent a lot of time together talking about things and doing things. One of the big things we did together, of course, is the history of the Northern District, which you have in your hand. And luckily, my wife's abilities as a historian aided greatly in the preparation of that. She went over to the State University Library, did a lot of in-the-stacks kind of research. I think it's one of the most comprehensive histories that we have of the courts of the circuit. She has a master's degree and has been a student and teacher of history for many years. One thing that we were very much involved in together was a project of hers, and we even had the kids down there. She did her doctoral research on a pre-Columbian civilization. And so we found ourselves in the Yucatan and Mexico very frequently going through ancient ruins and cataloging them and looking at them and preparing her notes for them. And at one time, for some years, we had a house in a little fishing village called Chelem near Merida, the capital of the Yucatan. And we were on the water there, and we had accessibility to a lot of Mayan sites within that area, and we traveled extensively looking at them, going so far as to go to Belize. We drove down by jeep to Belize. In those days, Belize was a very undeveloped place, you must understand, and the capital city was a horrible mess, and but they did have some interesting Mayan ruins along the way. It was an interesting civilization, and I was constrained to learn about it because she was learning about it. But her experience as a historian was very important to us. There's a whole methodology that the historians use, and she was able to apply that in the history of the Northern District as well, of course, as in her own work. She started out as an industrial chemist, and was the first woman to work at the Stauffer Chemical Company in Westchester County. In those days, Hans Stauffer was a German, I guess, immigrant who built this chemical company, and he didn't have any women working at it. His secretaries were men. But my wife came highly recommended by one of her professors, and so she began her career as a chemist, but later on turned to history.
Just maybe in a similar vein, perhaps you can share some reflections of any particular colleagues on the Second Circuit who stand out in your mind.
Well, I only got to sit once with Henry Friendly. Of course, he was one of our great judges, who was one of the two whose likeness is reproduced in our courtroom. But I've enjoyed collegial relationships with all the judges that I've sat with. The Second Circuit is a very collegial court, and all the judges get along well with each other. The senior judges are particularly helpful, and have been over the years. I miss some of the colleagues who passed on, Dan Mahoney, Frank Altamari, some of those who retired, George Pratt. It's always been a collegial court, and now I think Judge Feinberg is a senior. He was the chief judge when I came on. He's the senior. Judge Oakes, you've talked to him, who is has a very in-depth kind of a background, having been Attorney General of the state of Vermont, and all the people who have served as chief judges have been very accommodating to their colleagues. I must say that when it comes to scheduling and allowing the seniors to choose the times when they wish to sit. Judge Newman was particularly good. Judge Winter, when he was chief, they were just very helpful and very kind to their colleagues. They'd accommodate any views. They're one of the chief judge who shall remain nameless once said it's when you're the chief judge of a circuit court, you have a lot of people working, but they're not working directly for you. You're like the maestro who raises his baton. Everybody may play a different tune, So it's through persuasion and ability to get along that the chief judges, I think, have been so good that we've had. And the present chief judge, John Walker, is very much in that tradition. Judge Meskel served for a year. He was good. Whoever served as chief judge, I've had a lot of respect for. They have a lot of administrative work to do as well as their sittings, and they've all been fine, and I've admired them all. Plus, the judges, all of the judges. I think there's no particular one that I would say stands out over another. They're all wonderful people to work with. It's a very intellectual, challenging experience to be with them and talk to them, and I continue to enjoy this process very much.
I wonder, in a broadly philosophical vein, if you'd like to share with us any thoughts you might have on changes which have occurred through the years in the nature of law practice and in the role of the federal courts in our society.
Well, I think as far as the change in the law practice that has happened, we have seen a proliferation of lawyers. In my day, there weren't that many people, it seemed, who went into the legal profession. Now the law seems to be becoming a background for people who want to go into other things. My own son graduated from New York Law School, is now in investment banking, for example. People use it as a springboard for other activities. And a lot of them go into it not knowing why they're going into it. And they find later they don't like it very well. So that's, I think, a bad portent. I think there are probably too many lawyers to chase the business, the legal business that there is. And so lawyering has also become a very more competitive business, and too much competition is not good. In my day, it was much more collegial among the bar. When I came to practice in Hudson, other lawyers would try to help me and explain things to me and tell me what to do. When I worked briefly for a lawyer in Brooklyn when I was going to law school, lawyers down the hall would stop by and they'd chat, and you could go down and see them and ask them about your problems and so forth. The mentoring was much closer in those days. Now the large law firms have to get that hourly billing out. They have to make enough money to pay the huge overheads that they have now. Even the smaller firms have much larger overheads, libraries and help. We had basically one secretary in our practice. She's still alive. She started with my father out of high school, and she stayed with him until he died, and then stayed with my brother and his wife, who took over the practice. And so there was continuity of all kinds. I see a lot of movement not only in office help, but in the lawyers themselves who are moving from town to town. There's not that rooted system that there was years ago. I think that it's become a much more rough kind of thing to practice law. It's not as collegial, not as friendly. They've developed this you have to kill him at all costs theory, and do what your client say. Your client always wants to kill somebody. They say, I don't want you to give them an adjournment. Why did you give them an adjournment? That happened frequently. And we always used to say that's certain things confided to the lawyer. But the client doesn't understand that, I had one lawyer recently arguing a case, and I said something, she said, I would do anything for a client. And I'm saying to myself, well, whoa, you don't do anything for a client. You do what you can do within the bounds of propriety. You've got an obligation to the court. You've got an obligation to the bar. You've got an obligation to your profession and society. It's not just your client. But however, with the desire to serve clients above everything else, it leads to the problems that a lot of lawyers have now. And, it's the lawyer is not supposed to be Attila the Hun and just burn down everything in his or her path. I heard one lawyer once say, ask about why they did something, and he said, I'm a litigator, as if that somehow excuses impolite conduct, or it's just something that I think that judges have to take a greater interest in, making more of the fact that lawyers have to be collegial and they owe each other some respect and consideration, as well as the courts. Now you see more disrespect toward judges and so forth. It's all, people just don't have, I think the lawyers need some more, again, I use the word collegiality. They're all part of a profession. And it was very interesting to me when my wife and I went to London some years ago and visited Legal London, and watched the way that the barristers treat each other, and the way they treat the judges, and the way the judges treat them. And it's something that I think we could take a good lesson from. I think we need some help along the way to improve the profession, to better the profession, and not to make light of it. I think we all owe an obligation to the legal profession, and I, for one, think not only lawyers but judges should be aware of that.
And what is your view on the role of federal courts in our society now, as opposed to the years when you first came on the bench?
Well, the courts basically exist to resolve disputes between people and the government, between even intra-government disputes. It's a dispute resolution kind of setup. And I have always thought that matters of important policy should not be undertaken by the courts. Now, the problem is that in recent years, courts have had this thrust upon them, have been asked to resolve disputes that people can't resolve among themselves. My wife and I always have laughed about a fellow who came to court who was a state assemblyman, and a good friend of ours. When I was in a state court sitting here in Albany, he objected to the sales tax, I think, being passed, and he argued against it on the assembly floor, and he lost. And so he brought a lawsuit. They come to the judge and you resolve this problem. There was a case not too long ago where the senators are going to court on the question of the campaign finance law. I mean, elected representatives coming to courts. I mean, it's strange that these are the same people who say, oh, these courts are terrible, you can't trust them, they're the worst people in the world, they're not elected, they don't have any understanding, we need strict construction, and so forth. And on the other hand, they're saying, help me out here. We can't get anything done. And so it is that a court is a place where people know things get done. People come with a case to us in the Court of Appeals, we have to make an opinion and resolve it. We can't put it on the table, table the resolution, or postpone it, or wait till we get a word from our constituents. We've got to get out there and decide the case the best we can. And so that is a comforting thing to many, but I think that as long as these questions are presented to us, we've got to do something about them, and it's very difficult. our good friend in Hamilton, late Hamilton Fish, who was a congressman for many years, said at one time. He said, well, he was making a speech. Somebody asked him, how come that the legislation, the congressional piece of legislation, was so confusing? And what did it mean to say? He said, well, we let the judges like Roger Minor answer that question. So you know that a lot of legislation is passed in Congress and in the state legislatures where it's purposely made muddy to confuse constituents. And so that they don't have to say that I took a position here, I took a position there. They can say, hey, I went to court and the court decided that. I can't do anything about it. And so I don't think that's a particularly good trend. But it is a trend that we see more and more. People use the courts to resolve issues or to get through agendas. And when I talk about some of my cases, I want to talk about that, because it seems to me that this is kind of a misuse of the court system.
Ralph?
Judge, on a little bit different note, perhaps you could reflect on your service on various court committees over the years, and in particular any of those that you found
well, I've rotated through a lot of committees on the circuit court, committee on procedure, the historical committee, which I was very active with my wife for many years, a number of court committees that it was a duty to serve on, and I was happy to do it. The one committee of the Judicial Conference of the United States that I served on was the Federal State Relations Committee, and that was thought to be an interest of mine, as it has been for many years. I've written on it, the juxtaposition of the state and federal courts and state and federal legal systems. And I found that a very rewarding experience. As you know, the Chief Justice appointed those committees, and we went to meetings in various parts of the country and in Washington to deal with matters that we passed on to the full Judicial Conference for their action and consideration. So that was an interesting committee. Other than that, I think that it's a duty of every judge to serve on court committees as they can, and to participate in judicial conference committees if they can. The present chief judge of the Northern District, Judge Scullin, who was the U.S. attorney when I started in district court, is presently serving as a member of the Judicial Conference of the United States from the Second Circuit. I have a district judge, of course, and Judge Walker. And so for many years, Judge Foley was never interested in it, and I think, they kept passing on. I said they ought to be a representative from the Northern District. I talked to Judge Scullin about it, and he put his hat in the ring, and they decided that we have finally one judge who has served on the Judicial Conference Committee, and it's very interesting. He's told me about the experience and so forth. Before that, he served on the Judicial Conference Committee involving the financial disclosure statements, our favorite topic as federal judges, telling everybody what we have.
Judge, I cite the case of Quill versus Vacco, which, for the record, your opinion is at 80 Federal 3rd 716, 1996, and the Supreme Court opinion at 521 U.S. 793 in 1997. And this was a case in which it came up to the Second Circuit with the plaintiff doctors appealing a summary judgment for their action to declare unconstitutional two New York statutes which penalized assisted suicide involving the provision of drugs to terminally ill, mentally competent patients. As I've indicated, your opinion, which held that the statutes violated the Equal Protection Clause, was reversed by the Supreme Court.
Unanimously.
Now that the Supreme Court has reversed your opinion, what are your concerns about the effects of its decision?
Well, as in all cases, I rendered a decision the way I thought it should be. I had two colleagues who agreed with me, and the Supreme Court disagreed. of course, you know the old expression, the Supreme Court is not final because it's infallible. It's infallible because it's final. And they gave the final word on it. I think that there is a serious equal protection question. I still believe that. The Chief Justice did not, although I think he missed the point. He said that the removal of hydration, for example, and life support systems did not cause death. That would be caused by the underlying illness. And it was different in the case of a person who wished to take pills to end life and thereby terminate. Now, the question wasn't, to me, how you do it, but the question was choice of termination of life. Now, the person who knows that they're on life support system and cannot live without it and makes a conscious effort to have it withdrawn has chosen to terminate life because there's nothing left. And as I said, in my opinion, what business is it of the state to become involved in that kind of a decision? So the basis, for my opinion, was that there is no real distinction between a conscious, understanding person terminating his or her own life because, with the assistance of a physician, because there is nothing left of that life, and it's well known that there's nothing left of it, and there's no question that there's nothing left of that life, and the person who withdraws, consciously withdraws the life support system, knowing that there's nothing left of the life. Now, in my opinion, of course, I said that, certain safeguards definitely should be established, that there has to be no question in the mind of any competent physician, at least two, that life is at an end, and that there's a psychological evaluation that the person understands that what they're doing is understands that they have a full understanding of what they're doing, and proceeds only after those safeguards are in place. Now, it's well established that a person can consciously direct the withdrawal of life support systems. The Supreme Court has said that and didn't say anything to the contrary in this case. The only question that remained was whether physician-assisted suicide is comparable to that. And I said that it is. Now, getting to the upshot of the case, and I'm not talking now about whether you think this is right or wrong. Again, we have to make the distinction when cases that involve big questions of policy, have to make the distinction between what we personally feel as a judge and what we think the law says. And the law of equal protection, I think, applies in this case, although I don't think the due process law that my colleague in California said would apply. But the upshot of the matter is that there are certain judges, I think Justice O'Connor may have written for some of the concurring judges, that if a state wants to impose such a law, then maybe that's okay, because then it's the state that prohibits assisted suicide. The state could set up a system to do otherwise, although those concurring judges didn't see the Constitution requiring an invalidation of the assisted suicide laws. So now there's a body of public opinion that says, okay, states can do it. Now, the state of Oregon, I believe, did it, set up some kind of a statute to allow physician-assisted suicide under these extreme conditions that I described, that is, that there is no hope at all left for any life. And that has been litigated. The government has taken them to court to litigate, and the Attorney General, I believe, has threatened the prosecution of physicians who misuse, as he would put it, drugs by prescribing them to patients for this purpose.
It's John Ashcroft, for the record.
Yeah, and so, these kinds of threats would prohibit physicians in a state like Oregon, which permits this kind of thing, not to do it. So you are thwarting the will of the people in that regard. Now, there's another phase of this thing, and that's the palliative care that's done, the terminal medication, they call it, where physicians administer medication. And it appears to be no secret. These people who were parties to this case have written on this extensively, Quill and others. The physicians administer as much pain-relieving drugs as is necessary in the terminal phases of an illness. Now, sometimes that administration will cause the death of the patient. And now, again, you hear people who have some kind of a conservative approach to this thing saying, well, now, wait a minute. If this is going to kill people, don't give them that much drugs. And yet the purpose of it is to prevent pain. One of the biggest problems, according to some articles I've read, is that physicians are not well enough versed in pain management. And a lot of people suffer enduring pain unnecessarily because they're afraid to prescribe too much medication. But yet, it would seem that generally speaking, that if the medication is prescribed for palliative purposes and the effect of it is to cause death, and the patient says, I want as much of that medicine as you can give me to avoid pain, knowing that that too will cause death, isn't the physician administering that as well? So out of this is going to come, a lot of people talk about the slippery slope that this sort of thing will do. But I think as more and more the population is aging, a lot of people are turning their thoughts to this sort of thing and where it should go. And again, it's one of those public policy things that continues to find its way into the court system. And the Supreme Court hasn't yet given a word, because it hasn't been tested, as to whether a state like Oregon, the laws there will stand up under scrutiny at a higher level. So it's a continuing problem, and I see no end of it in sight, at least at the present time. It's totally not resolved. And of course the problem is it leaves physicians, who are really the ones concerned with the treatment and care of patients, in a quandary about what to do. And I don't know how much training they give them in medical school about making decisions and ethical questions. They give them some, I guess, but the guidance is not clear to them. What do they do? Should we give them more morphine, even though it causes death? Shall we prescribe this kind of pill, even though too much of it will cause death? We know that we have to withdraw life support if it's called upon by a competent patient for us to do, just as you have to be competent to decide that there's no time left and you might as well have a physician prescribe some pills for your death. Again, it's a continuing problem, and it was particularly surprising to me that, my opinion, didn't draw one dissent in the Supreme Court. And just as an aside, we usually don't say these kinds of things, but there had been an initiation of a request for an en-banc of our panel decision in that case, but it was headed off by the Supreme Court when it grabbed the case so quickly on cert.
Judge, in the context of this case, I'd like to focus a bit on process that may perhaps be troubling the public. And you alluded to it. You and Chief Judge Rehnquist, examining the same case and the same phenomenon, came to diametrically opposed conclusions as to what happens when a mentally competent patient in the final stages of illness orders the withdrawing of medical treatment of terminal life support. You wrote that there's nothing natural about such a death because it is caused by starvation, dehydration, or asphyxiation, not the natural progression of the disease. But the Chief Justice states flatly that when a patient refuses life-sustaining medical treatment, he dies from the underlying fatal disease or pathology. I'd be interested in your thoughts about two learned and experienced judges, yourself and the Chief Justice, examining the same exact subject matter, yet reaching such radically different understandings.
Well, I guess it's a matter of how you look at it. Reasonable minds can differ, I suppose. I just see it in a different context than he does. As I've said, he sees it as a question of how you die in an extreme condition. And I say it's a question of the choice of termination. And it doesn't seem to me that refusing life support systems and choosing to die that way because you're in the final stages, or choosing to die because a doctor is helping you to achieve that end, is any different. Now, you can go through the medical aspect of it, I suppose, and you say, well, you're not dying of dehydration or whatever it is, but you're dying of the underlying ailment. I don't know whether that's true or not as a medical matter. I don't know what a doctor would say, and that might be an interesting question. Obviously, if you don't have enough food or water in your system, you will die. And whether a post-mortem examination will show you died of that or of the underlying disease, seems to me that might be different in every case, or it might be different from one case to another about what you actually die from. So I still don't fully agree with his approach to it, although I understand what he's saying, and of course we'll have to apply that rule in future cases.
And Judge, one more question regarding this case. This one, as well as many others, involves the most fundamental issues, those of life and death. Is there anything you would change in legal education and training to help lawyers and judges cope with these questions?
Well, I think it's important for the lawyers and judges to be up on the latest legal doctrine on the subject. Well, to be very frank, I think it's very much more important for the medical community to be aware of these problems and to be up on the latest doctrine on the subject, because they're the ones at ground zero doing the main, being mainly concerned with these questions of life and death, and how they handle them is very amazing. You know, to me, a lot of doctors take the position, well, I've got malpractice insurance, so I'm not going to worry about too much about doing the right thing here. But they all seem to worry about matters of life and death, and they worry about giving too much medicine, and the fact that they have to report that. You know, it's one thing to be considered negligent in your work. It's another thing to violate laws and prescribe medicine that isn't supposed to be given, and to withdraw feeding tubes, and the question of who has the authority to order them, and what do you do with somebody who is not in a position to make that decision, and the whole idea of living wills and the idea of health proxies and so forth. These are all things doctors get confused with, and I understand that sometimes you can present a health proxy and they won't even pay much attention to it. These are important matters, not for lawyers and judges, although they are very important for lawyers and judges, but not as important as they are for physicians and healthcare people. And so I think those are the people who should be very much aware of where we stand in this area.
Ralph?
Judge, let's talk about another case, Lamb's Chapel versus Center Union Free School District. Your decision is reported at 959, Federal Reporter 2nd, 381. It's a March 18, 1992 decision. The Supreme Court's decision is reported at 508, U.S. Reporter 384. It's a June 7, 1993 decision by Justice White. In that case, a church and a pastor brought an action challenging the constitutionality of a school district's refusal to allow a church to use school facilities to show religious film series. The district court granted summary judgment, the summary judgment motion by the school district, and the pastor and the church appealed. In your decision, in some, held that the school facilities were limited forums not open to religious uses by policy or practice, and there was therefore no First Amendment violation in the school district's denial of access. Justice White's opinion distinguishes between prohibiting the use of a school district's property for a religious purpose or a religious use and allowing that property to be used to examine a subject from a religious viewpoint. Are you concerned about this distinction? Do you think it's an accurate distinction? And if so, why are you concerned? Do you disagree with that distinction?
Well, I've come around to pretty much accepting the concept that speech from a religious viewpoint is acceptable conduct for the use of a school. Now, and of course, it's the later development of this concept that has caused me concern. Even though I was reversed in this case, I have no problem accepting it because this Lamb's Chapel against the Center Mauritius School District case involved the use of school premises for various, I guess they had some films and programs devoted to various topics such as child rearing and what to do in the home and matters of that nature. Now, of course, those are the same kinds of topics that many of the other organizations that use the school facility for were involved in. How to raise children, for example. Those are things that if you're going to let people in to talk about, I think speech from a religious viewpoint, you say, the religion tells you to do this and to be good people and to, it's not directly contrary to the concept that they have in New York State that the church shouldn't be involved in school matters. And so I don't think that I have a problem anymore with the Lamb's Chapel case, although I would have decided it differently. It's where they went from Lamb's Chapel that has caused me concern.
Well, let's just finish up on Lamb's Chapel. Given your examination of the record in this case, what was your reaction to the Supreme Court's conclusion that the school district's fears of an Establishment Clause violation were unfounded?
Well, I could accept that decision. I didn't. I thought that it would be best if the church matters could be kept out of the school, but the Supreme Court's approach to it and what I considered, the way they hemmed it in at that time was acceptable, a way to go. The future of those kinds of programs seems to have been assured, and it turns out the schools were willing to live with that, that they would have to provide programs that allowed speech from a religious viewpoint of all kinds of things. It's just a viewpoint. It got different when we got into worship services.
That brings us to the next case, the Good News Club versus Milford Central School. Your decision was reported at 202 Federal Third Reporter 502. Your decision's a February 3rd, 2000 decision. The Supreme Court's decision was a June 11, 2001 decision, of majority written by Justice Thomas. Justice Breyer concurred in part. Justices Stevens, Souter, and Ginsburg dissented. Justice Thomas's decision characterized this case as involving an issue of whether a concern about an Establishment Clause violation provides justification for violating free speech rights. What is your reaction to that characterization of the case?
Well, he framed it in terms of free speech rights, and I guess we're talking about free speech rights, but here we have a completely different set of circumstances from Lamb's Chapel. And ultimately, he tries to say that this is only speech from a religious viewpoint also. It's not. And he characterizes it the way he wants to characterize it. This is a case where you have young children, as young as 6 years old, involved in this evangelical situation where they're being asked to be saved, or they're being taught that it's important for them to want to be saved, having them pray, and being involved in what is more directly a religious situation. And this is not just speaking from a religious viewpoint, as some of the dissenters in this case point out. You're getting into prayer here, and you're getting into using the school for the kind of religious purposes that the people of the state of New York have decided they don't want their schools used for. And it's very strange to me that these people and you can see as these cases go along, these are what I was talking about before, these are kind of test cases. They're pushing public policy. They're pushing, the people who want to get into the schools with their churches have pushed and pressed these cases. And you can see even some of the attorneys are the same. And the situation is that we have a movement here that the courts are being used for to overcome the will of the people. In effect, the people concerned about the will of the people ought to be concerned about the fact that the people don't want religious services in their school. Now you've got impressionable young minds. You see, the Santa Marici's case, the Lamb's Chapel, that was going mostly adults and older people, older children and so forth in there looking at these, how to raise a family from a religious viewpoint. Now we're looking at impressionable minds and other students in the school looking at them, going into this thing, and they get certain treats and candies and so forth. They have to talk about being saved, and they have to adhere to the religion that's being promulgated to them. Now, of course, they don't have to go there, and their parents don't have to let them go there. But that's not the point of the thing. The point of the thing is that the schools in New York have been closed for religious use. And there's plenty of places for people to go to conduct their religious services. And there's plenty of places for them to go to hold these kind of Sunday school events as this one. They don't have to do this in the school. The Good News Club is the good news of the coming of the Lord and so forth and so forth. That's all well and good, and people should have the right to do that. But why the schools? Because these people want to get themselves into the schools. And I think that there is no need here to overcome what has been said by the people in keeping their schools for uses that they prescribe. And I think Justice Thomas really mischaracterized what goes on in this Good News Club, in these Good News Club meetings. He mischaracterized it. He also took me to task for not following the opinion of his in Lamb's Chapel, I guess. But that wasn't his opinion, but the opinion of Lamb's Chapel. He thought that I ignored some case, and I didn't. I understood. I saw a distinction here.
Good News and Lamb's Chapel address the relationship between the free speech clause, and in particular viewpoint discrimination, and the Establishment Clause. What are your thoughts on the relationship between these two constitutional provisions? Should one be superior to the other, or how do they interact?
Well, these cases have really involved the speech provision, although I see some Establishment Clause problems, particularly in the later case that I did. But these are basically questions of what speech can be restricted. Now, if you have a limited public forum, as a school is, they can set forth what kind of speech they want to have in their forum. School is a particular kind of place. The New York state law for 60 years has been the same. The school boards can allow these various organizations to use school property. There's no provision for them to use school property for religious purposes. But now, of course, we can say that it isn't fair from a First Amendment point of view. It doesn't comport with the First Amendment to say, well, you can have organizations giving viewpoints of all kinds, but not religious viewpoints. Okay, now we can have religious viewpoints. The Good News Club operations do not entail speech from a religious viewpoint. It isn't that. It's teaching of religious principles, the inculcation of religious principles. It's the prayer that is taking place. All those things take place there in those meetings. And for Justice Thomas to brush it off and say, no, that's just speech from a religious viewpoint, it's different. It's different from the Lamb's Chapel case. And I see it as different, and some of the justices saw it as different.
Judge, rounding out sort of a trilogy on this topic is Bronx Households, as far as this circuit is concerned. And there have been two cases styled Bronx Household of Faith versus New York City Board of Education. One in 1997, where you wrote the opinion for the Court of Appeals, and one in 2003, in which you wrote a dissent. And this involves the effort by plaintiff Evangelical Christian Church, which challenged the school board's refusal to make a school auditorium available to it for weekly religious services. You've discussed the principles at stake. I wonder if you could analyze for us, in terms of people's daily lives now, what do you think was gained by Household 1 and lost by Household 2?
Well, Household 1, we made the distinction, or I did for the majority.
And please let me state for the record, Household 1 is 127 Federal 3rd 207, and Household 2, 331 Federal 3rd 342.
We saw Household 1 as a pure religious kind of a case, conducting of religious services, actual religious services in the school. And we saw that as different from both Lamb's Chapel and the Good News Club. The Bronx Household case, when it came around a second time, had now behind it the Good News Club case in the Supreme Court. My colleagues saw the Good News case as compelling them to, in effect, overrule Bronx Household 1, because it's the same church and the same kinds of services, and everything was really the same. The school regulations were the same. Everything was the same.
This was a decision by Judge Cardamone, joined
Yes,
by Judge Katzmann.
I saw a distinction, just as I saw a distinction previously. I thought that the Lamb's Chapel case established a rule dealing with speech from a religious viewpoint. And both Bronx Household 1 and Bronx Household 2 involved the same set of circumstances, a church wanting to conduct services on a Sunday in the school property, which is prohibited according to the New York law. Now, New York amended its law in the light of a Lamb's Chapel and, I guess, Good News Club, to say that, okay, we still prohibit religious matters in the school, except for discussions from a religious viewpoint. Now, unless you can relate speech from a religious viewpoint with religious services, then I don't see how the Supreme Court opinion compels the majority to rule as they did in Bronx Household 2. We go through, or at least I try to go through, all the things that they do, both majority and the dissenting opinion, talk about how this comes down in the context of religious services. Their prayers, their readings from the Bible, there are preachers, and there's communion, which is a quintessentially religious thing. And what Judge Cardamone is saying, as I see it, and his baptisms, they're the regular things that happen in a church service, which weren't the things that happened in the Good News case, because that was young children being educated, although being prayed and so forth and so on, or Lamb's Chapel, which was just some films on family life and a religious viewpoint. This is the actual worship services. And so I saw, again, a distinction. And Judge Cardamone is saying, well, it's also speech from a religious viewpoint, and you can't separate the two. Now, this may very well be where the Supreme Court is going, because that's where they've been going from the very beginning here. And that's where the people who impel these cases want to take it. They want to bring religion into the schools.
You made particular reference in Bronx Household to the affidavits filed by the Bronx Household
Right. They
preachers.
tried to minimize in some way the worship end of it. But it's not to be minimized. It's a church service. Now, if the people of the state of New York wanted to have a church service on Sunday, I suppose they could provide it that way. We have people, again, who are very important proponents of states' rights saying, well, wait a minute, the state doesn't have a right here. We want to get these matters into the schoolhouse. And so, in my opinion, as you can see, I've not only made the distinction, or I think is important distinction between worship services and speech from a religious viewpoint, and using definitions, dictionary definitions about what worship is. I think I pointed out, I think, some problems that are going to arise as a result of this. Now, New Yorkers have always wanted to keep church and state separate. And so now we have a situation where this school is going to be used for religious services. Other schools then will have applications pending before them for the same thing. There'll be conflicts, inevitably, between various denominations who want to use the school at the same time and at the same place. And the school will have to choose among them. And in getting into the choice, are we getting into problems of the First Amendment religious end of it? Are we preferring one religion over another if we allow a choice to be made about who's going to use the school? And then you have the use of the school on Friday, Saturday, and Sunday. I remember when my wife and I were in the souk in Morocco many years ago, and the guy says, we'd like to live here. We have Friday, Saturday, and Sunday off. He says, Friday for the Muslims, Saturday for the Jews, and Sunday for the Christians. So, you know, you're going to have Friday, Saturday, and Sunday requests for use of the facility. Again, conflicting among various sects and religions. And you're going to have that problem. It may get to the point, and here's the policy problem, you know, I shouldn't really be talking about, because I don't think it's a matter for the courts to get involved in policy matters. But look, you may get to the point where a school says, that's it. Nobody gets in here. We're not letting the Boy Scouts, the Girl Scouts, we're not letting the community church, we're not letting anybody use the school anymore. It's just too much trouble. If you got some kind of genuine educational program affiliated with the school, then you can use the school after hours, or after hours school programs, after hours athletic program, whatever it is, but we're not going to let any outside people in. And what is the Supreme Court going to do about that? They've closed the forum under those circumstances. You don't have a half-open forum, or you just got a closed forum altogether. And that may well be the upshot and the result of these decisions. Now, this case may not get to the Supreme Court, because the Supreme Court, in its present configuration, would have been content with this case and will deny cert, probably. But certainly when you have something that is totally religious in nature in the nature of a worship service, standard worship service, then it seems to me that that's an issue that has not yet been before the Supreme Court. Unless they too, as Judge Cardamone did, want to classify it or reclassify worship as speech from a religious viewpoint. I just don't see it.
Judge, you obviously put a great deal of time and effort into your dissenting opinion. Using this as a springboard, what would you hope over time would be the value of having that opinion in black and white? And in general, what do you see as the function of dissent, since you obviously, along with your colleagues, put a great deal of time and effort into them?
Well, I don't dissent very much. Dissenting, I try to throw in with the majority, even when I have some doubts about it, because a dissent, doesn't mean too much unless it's really something I'm concerned about. Somebody said that a dissent speaks to the conscience of another day. And I think that in this case, I'm just putting forth for posterity, in case this case does go forth to the Supreme Court, or in case maybe some other circuits or other courts throughout the country want to think about this situation, that I put everything down that I think is pertinent to where I end up in this case. So I've done it a thorough job because I thought that everything should go into it that should go into it. And it's really an analysis of the prior direction of the Supreme Court and saying, well, maybe it should stop here. And so I don't have any great hope that things will change or any even great hope that this will go to the Supreme Court. But I felt strongly enough about it that I wanted to make a record of my position on it and give the reasons for my dissent. It wasn't done in an effort to make a lot of waves, but it was to make a point. And obviously, my colleagues and I used the system that we use very frequently in our court of memoranda back and forth about how we think the case should go and whether this was a close case among us as well, but two finally ended up on one side, convinced that the Good News Club case would be controlling.
Judge, are there any other observations that you would like to offer on your life in public service and as a federal judge, particularly?
Well, I've enjoyed my life in public service and as a federal judge and as a practicing lawyer. This is not a bad place to finish up your career. The Second Circuit Court of Appeals is always challenging, always interesting, always working with fine people and getting to do things that are enjoyable, and yet as a senior judge allowing me to do other things like teaching and writing. I think it's an obligation, and I've said this in the past and other places, that judges as well as senior lawyers have an obligation to teach others and to help others understand what they do and what the law is all about. And so over the years I've undertaken teaching assignments at various bar associations and bar functions and so forth. Lawyers are always happy to hear from judges what they think and what they do. And I think lawyers have an obligation to do that too, to teach in colleges and law schools. And in my day, the faculty was very heavy with adjunct professors, that is, professors who were in practice and taught also. And so I taught at New York Law School for many years, a course in federal crimes. That's the course I'll be teaching in Arizona this year. I was here at Albany Law School for many years teaching appellate practice. And that included taking my students on a one-day trip when I was sitting to watch the circuit operate. And we always got a lot of help down there. Roseanne McKechnie, our clerk, was always very helpful. She, in fact, is a teacher had been teaching at Brooklyn Law School on appellate practice. Had a career herself as an appellate lawyer. Even our interviewer here today is going to teach appellate practice, and I think that's a great thing for students to be able to learn from somebody who is in the field and doing it, because I don't think the students are getting enough input from outside. It's one of my concerns also today, and I've expressed this, and other judges have written about it. There seems to be a great disconnect now between the academy and the practicing bar and judges. Academics seem to be talking to themselves. You read some of the law review articles and some of the things. We used to follow law review closely. They're talking about things that really have no practical application to what we're concerned with here. And I don't think that that's a good thing. I remember when I was on the board of trustees at New York Law School, they'd bring in new professors introduced to the trustees. Hey, this person's going to join the faculty. She's interested she'll teach first year torts, but she's really interested in XYZ, the philosophy of basket weaving law, or something like that. And so that disconnect is what bothers me. I think in my day they trained lawyers. We use the word training of lawyers more than now. And the curriculum of law school is such you don't have any required courses after the first year. Some people graduate law school and never have taken evidence, for example. Courses that were required in our day. And you really can't be a lawyer that way. And the reliance has come too much, I think, on the bar review courses. The students figure that they get the information they need to pass the bar exam in the bar review courses. They should get most of that information in law school. And the bar review course wouldn't be necessary. I never took a bar review course, although I had some notes from one and some notes from others that I had taken, from courses that I had taken. That's how I studied for the bar. But today, it'd be kind of a freak of some kind if you don't take a bar review course. So I think the schools have to get with it a lot more, and I think the way for them to get with it is to have lawyers, practicing lawyers, and sitting judges come and teach in the law schools. And that's not to say that we don't have an obligation to the practicing bar as well. But I think we get them early, get them young, and teach them the right thing, teach them the right stuff.